A Nevada last will and testament is an essential and rather simple document that ensures an individual's estate is properly managed after their death. Best of all, a will can be often created without hiring an expensive lawyer. In this video, we'll go over the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Nevada, and how and where to create an official will. Let's begin by looking at wills and their importance. A last will and testament, simply known as a will, gives an individual the opportunity to designate instructions on how they would like their property and assets to be distributed after death. By naming beneficiaries, usually spouses, children, and blood relatives, the maker of the will can select the individuals who shall inherit all or a portion of their estate. Now, what occurs if no will is left? A person who passes away without a will in Nevada essentially loses control of who inherits their property. Instead, state laws, through an intricate formula, dictate how the deceased assets are handled. The deceased spouse or direct family may inherit the property by default, but it differs from case to case. Leaving one's property in the hands of the state can cause loved ones to contest the decisions made by the courts when distributing the estate, which can lead to lengthy court trials and disputes. It is recommended for all adults to have a will, especially those who are elderly or facing life-threatening conditions. Making a clear will can make all the difference in ensuring that loved ones receive their fair share of the inheritance. What's best is that wills can be created without an expensive attorney required. A person of sound mind can draft a will in Nevada with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's briefly review legal requirements in Nevada. Last will and testaments in Nevada must be signed by the person to whom the will belongs, known as the testator, in the presence of 2 or more trusted and competent witnesses. Though optional, it is recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once all parties have signed, the document will be legally binding under state law. Several copies can be made and given to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for Nevada that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will, and don't forget to like and subscribe for more daily videos, and visit our website for more legal information.